Hi, it's Roland Jones. Thanks for watching. This is a video that will hopefully answer the question of why the preference laws exist, what are the rationales, and what are some basic defenses that you can use to defend yourself in a preference case. So you render services to a company, you deliver product to a company, you're paid, no one has any problem, everyone's happy. And then about 2 years later, you get a demand letter or you get a lawsuit asking that you return the money. But the company gets to keep your product and use your service. So how is that possible? It sounds crazy. Why do these crazy laws exist? What's the purpose of these preference laws? Well, there are two reasons. First is equality of distribution, and the second is the preference laws discourage a race to the courthouse. Well, what does that mean? I'm going to go into each of these a little bit. Equality of distribution. Basically, the theory is, some folks got paid prior to the bankruptcy in that special 90-day preference period, and they get paid in full. And then a bunch of other creditors get paid after the bankruptcy case, and they get pennies on the dollar. So some creditors get payment in full, and some creditors get pennies on the dollar. So the theory is we're going to look at those creditors that got paid in full right before bankruptcy and see if there's any funny business, if they were preferred in some way, and make them return the money. And theoretically, all that money that's returned will go into a big pot, and all unsecured creditors will share in that money equally. It's all about the pie. To make it simple, there's a party, 4 people show up early, one person, they divide the pie in four parts, one person gets a slice. So with 4 people, that's a full slice. What these guys don't know is that there are really 100 people invited to this party, and 100 people show up a few minutes later, and everyone wants a fair piece of that pie. So the fellow that took a full piece before everybody else showed up is being preferred. He's getting a full piece, and now 100 other people have to divide up what's left, 75% of the pie. So that's what the preference laws are all about. We're trying to go back and see, well, is it fair for this guy to receive a full pie, a full share of the pie, if there are 100 people that have to share this pie? Race to the courthouse is actually kind of similar. The theory is we don't want super aggressive creditors in the preference period. Perhaps in the know creditors who know there's a looming bankruptcy to divide up the pie, to get chunks out of the debtor right before the bankruptcy. And why is that? Because we want the debtor's assets intact. We want to be able to access all these assets and distribute these assets fairly and equitably during the bankruptcy. So it's sort of a similar concept. The theory is these aggressive creditors are going to be discouraged from racing to the courthouse because they know that the preference laws exist and they know they're going to have to return the money anyway. So why bother? That's the theory. Not to mix metaphors, but I kind of like this analogy even better, musical chairs. So if somebody knows that the music is about to stop, obviously that person or people have an advantage over the people that don't know or maybe should know but don't know, and so there are going to be folks left without seats because of fast-acting creditors that knew there was going to be a bankruptcy filing or maybe had some information. Intent is not, and knowledge is not a factor in a preference case, but I like this analogy anyway. What is a preferential transfer? Surprisingly enough, it's never defined by the bankruptcy code. This is the statute. This is the part of the bankruptcy code that defines what goes on in a preference case. It sets out this is the definitional section. This section sets out the elements that a plaintiff, usually a trustee, is going to have to prove to win a preference case. I'm not going to go into all these elements. I do that in another video. And these are the elements that the defendant is going to have to prove to show that the transfer should not be avoided. What's interesting is that the code says, well, the trustee may avoid certain transfers or may not avoid certain transfers. It just sets out sort of the elements, but doesn't define preferential transfer anywhere. I sort of have my own definition of what a preference transfer is. A preference is any payment to a creditor while the debtor is insolvent, followed by a bankruptcy. Notice that it doesn't require any knowledge or intent on anybody's part. It could be accidental. The point is, it's back to the pie. The point is, that person is getting a bigger slice than maybe that person should get if there are 100 people dividing up the pie. But is it the fault of that person? Did that person intend? And maybe that person didn't know 100 people were going to show up later. And certainly the host did not know. I don't know how far I can carry this metaphor. But the point is, it doesn't matter. A preference took place. I'm going to talk about the preference period a little bit. It's very simple. Bankruptcy is filed. That red double arrow represents the preference period, 90 days. It can be a year for an insider, but I'm not going to go into that kind of complexity in this video. You were probably paid in this period if you're a non-insider and you're being sued for a preference. I'm going to jump right into the defenses to a preference claim. First one I'm going to talk about is the contemporaneous exchange defense. Basically what that means is that if you rendered a service or delivered a product, you were paid pretty much, I say pretty much, at the same time as you rendered the service or delivered the product. It's not necessary. I know I have simultaneous in this slide. It really isn't required that the transfer be simultaneous with an exchange for payment. But the theory is it's about the same time. Why do we have that exception? I call it an exception. It doesn't mean there wasn't a preference. It just means there's an exception to the preference laws. So why have this exception? So you go into a store, you buy bananas, you pay cash, you get your bananas. No debt was created. You didn't sign a promissory note to pay this guy later for bananas. There was cash exchanged. He's not a creditor. He doesn't become a creditor of yours because there was a pretty much simultaneous exchange. So why is that important? The purpose of the preference law is to make sure that creditors are treated equally. So theoretically, if a vendor is paid immediately, then he's not really owed any money, and he doesn't really have any pie issues, and so doesn't need protection. In this law, intent is required. Both parties have to have an intent that the exchange be substantially contemporaneous, but this can be shown circumstantially, and it's often not that much of a bar. The transfer must be substantially contemporaneous. What I find interesting is that courts have accepted transfers where there's a week or even 2 weeks space between the rendering of the service or delivering of the product and payment. To me, I think that creates a credit transaction because money is owed. But nonetheless, courts have found that if If the transfer is substantially contemporaneous, then really the intent was not, and the intent was not to create a debtor-creditor relationship, then these kind of transfers should be accepted from the preference laws. I'm going to jump into the ordinary course of business defense. If you Google preference or preference clawback, this is probably the first defense that anyone's going to talk about. It's usually the main defense to a preference case, and it's definitely the most litigated area of preference law, and possibly the most litigated area in bankruptcy law. Okay, so we want to use the ordinary course to protect us from having our transfer avoided. In other words, we don't want to give the money back. So what's ordinary? Well, one way of determining what's ordinary is by determining what's not ordinary. And what's not ordinary is any conduct that deviates from what is ordinary. That may sound circular, but it actually does have validity. What's ordinary is what happened over the history of the parties prior to the preference period. What the preference law analysis does, it takes a look at a period prior to the preference period, before that helter-skelter, chaotic slide into bankruptcy, and takes a look at the period before that, a year, 2 years, or a different time period, and looks at that period. And that's what's ordinary. What's interesting about the preference laws is that the laws changed in 1978 when the current bankruptcy code came into being. Before, it was called the Bankruptcy Act. And under the Bankruptcy Act, the plaintiff in a preference case was required to show intent, bad intent, on the part of a creditor, on the part of the defendant. So in other words, that the defendant knew or did something, took an act to be preferred. But here, under the Bankruptcy Code, that's not required. However, the burden has shifted onto the defendant, and now the defendant must effectively show that the defendant had no bad intent. And how does the defendant do that? Basically through circumstantial evidence. What I'm saying is not case law. This is my experience. After doing this for defending preference cases for 15 years, I am convinced that what really is going on in the judge's mind is the judge is taking a look at the circumstance of the case and deciding, was there really some kind of effort to be preferred here, some kind of affirmative action, either on the part of the debtor or the part of the defendant to get an advantage during the preference period. It's not spelled out anywhere, but that's my experience. So what we're going to look at is conduct by either party. Could be the debtor creating a special list of preferred vendors. I've actually seen a list like that, where they have a list and it's called preferred vendors. These are the guys we're going to pay. Or it could be an action on the part of a creditor, excessive, suddenly aggressive collection activity right before the bankruptcy. So it could be either party that's taking some kind of conduct that kind of stands out and seems to imply an affirmative, conscious action to get an advantage. We're going to oppose that with an accidental preference treatment. In other words, if you get paid during the preference period, as I've shown before with the pie, you're being preferred. But is it accidental? It's the accidental preferential treatment that is excused by the ordinary course defense. Now, what do I mean by that? I'll go on and show you. Well, accidental preference treatment basically means it was business as usual. In other words, nothing much happened. It was business like you always did business. And the bankruptcy or the looming bankruptcy or the financial distress of the debtor had absolutely no impact whatsoever on how you did business. And you can show that by demonstrating how you got paid in the preference period, compare that to how you got paid in the base period. So in a situation like that, it's basically an accidental preference, no intent, no affirmative action. But how do you prove nothing happened? How do you prove nothing happened? Nothing happened special in that period. It's like proving a negative, isn't it? I always like that picture. It seems to me that we're in the same. He's got to prove. He's got to prove that he didn't do anything wrong. Well, the first thing you've got to know is your knowledge or intent is irrelevant. I've said that a couple of times. So you didn't know you were being preferred. You didn't know you were on a preference list. You didn't know there was going to be a bankruptcy filing. You didn't know that the debtor was insolvent. That by itself is not going to help you. It's the facts and circumstances that must somehow show that nothing special happened. No special action was taken during the preference period. It's important to know that the "I do not know" defense simply doesn't work. I call that, and this is dating me a little bit, but I call that the Sergeant Schultz defense. I know nothing. Doesn't work. Why? Because who cares what you know? You're still getting preferred. You're still getting the big piece, whereas a bunch of other people are left to divide what's left over. You were preferred, so it really doesn't matter whether you knew or not. So that's really the $64,000 question. Did the debtor or you act in a different way? The best way of showing that you didn't act in a different way is to show consistency and basically a series of automatic payments unconnected to the bankruptcy or the looming bankruptcy filing. What's going on over at the debtor's place is it looks like this. There's a siege mentality. There are a lot of creditors banging on the door. What do we do? Who do we pay? The debtor's arm is being twisted. People are panicking, and the feeling is a lot like Custer's Last Stand. You have to ask yourself: is there anything that would indicate that the payment to you was paid from a siege mentality? Any change any change in the way you did business may imply a pressure or a looming bankruptcy. And I'm going to go into some of the typical changes that happen. Later payments. So all of a sudden, you were paid in 30 days for 5 years every month. And then during the preference period, all of a sudden you're paid in 90 days. It's a big change. That usually or may defeat the ordinary course of defense. And why is that? Because maybe the debtor paid you at the last minute right before bankruptcy. It didn't pay anybody else. So in other words, management got together and said, look, we got to pay these guys because we need their product or they're threatening us. And, we weren't going to pay anybody, but we'll pay these guys. So that's what I'm often asked. Well, why does a later payment take me out of the ordinary course? And, that may be why. Again, trustee does not have to show any of that, does not have to show intent, does not have to show bad faith or uh, a special intent to engineer a preference on your behalf. All he's got to show is that are later payments. That's all that's required. But that's sort of the rationale why later payments might take you out of the ordinary course of defense. What about earlier payments? So you're paid in, let's reverse it, you're paid in 90 days for 2 years every month, and then all of a sudden you're paid in 30 days. It's the same thing. I mean, there's a change. It's not ordinary. It's not how you normally did business, how you ordinarily did business, and who knows why. But it very easily could be a situation where you're applying collection pressure, or there's a reason, there's some reason to make sure you get paid, and maybe they're running out of money, so they're paying early. They want to pay you before they run out of money completely because you're such an important vendor. So, and I'm making that up, but that's an example of a reason why where there might be a conscious decision to pay earlier, and why that might result in a preference for you. Again, trustee doesn't have to show that. All he's got to show is that things changed, and that the ordinary course defense is not available. This is a fairly common thing. All of a sudden, you get paid by wire. You've always been paid by check. Again, same thing. It's arguably, or certainly the plaintiff is going to argue that it's out of the ordinary course, and the implication being, well, there was a rush to pay you for some reason. Why was there a rush to pay you? Why didn't other people get wires? That's that kind of thing. Could be larger amount of payment. Let's say you're owed 4 months of invoices, and all of a sudden you get a wire and you're completely paid off before the filing. Obviously, the implications to that are obvious. Again, the trustee doesn't have to go there. It could just demonstrate that it wasn't ordinary. There are also I call it a different kind of arm twisting. Well, basically, harder arm twisting, collection pressure. I'll give you an example. So this is, I wouldn't call this collection pressure. This is sort of a reminder note, and this might have been sent 85 times during the 2 years prior to the preference period, and then it's sent during the preference period. So, argument that it's ordinary. Plaintiff might argue that it's not ordinary. Go back and forth. But take a look at this one. Okay, we're not going to ship any more products, pay up. So is that out of the ordinary? Was that ever sent before? Is that unusual? Was there a response to that? Did you get a wire because you sent that? It's the implication. Not only is the plaintiff going to argue that never happened before, so it's out of the ordinary, but the implication is some conscious effort was made to get your preference. It wasn't accidental, and it may have been related to the financial difficulty of the debtor if that was never done before. Of course, the defense is going to argue that it's not, and it may very well not be out of the ordinary course. In fact, one of the arguments that it's not out of the ordinary course is you could say, well, we didn't get let's say you didn't get a wire. Let's say we sent that email and you got a check a month later. So you could argue that the email really had no effect on whether you got paid or not. Whether the email was out of the ordinary course or not, it's really irrelevant because you got paid the way you normally did. So, there are arguments back and forth. Typically, to show consistency, you're going to look at the days outstanding of how you were paid in the base period. Compare that to the preference period. And voila, you also receive payment of all invoices in 11 days during the 90-day preference period. So what does that show? It shows consistency. Is that a slam dunk case? Not necessarily. Did anything else change? Were these sent by wire in the preference period, whereas they were sent by check in the base period? Were there larger invoices? There are other factors that may come into play, but this does show consistency. So it goes a long way to help improve an ordinary course defense. So this is an example of a more realistic example. One of these payments in the preference period are in 20 days, or two of them are in 20 days, and one of them is in 15 days. So there's more variance, and that's really what you see more often. So it's a 20-day payment out of the ordinary course. Lawyers are going to argue back and forth about that and look at the various factors. We're going to look at payment averages. What's the average days outstanding in the preference period? How does that compare to the base period? So an indication of consistency. Range of payments. If you were paid between 30 and 90 days in the base period and you were paid in 40 days in the preference period, you can argue you were paid within range. Again, it's an argument of consistency, of similarity. If there's no prior history of payment, there is some case law that says that if you were paid pursuant to terms, then that's ordinary course. The industry standard is another way of showing ordinary course. It's an alternative prong of the ordinary course defense. You can either show the ordinariness between the parties, or you can show the industry standard, or you can show both. The industry standard is pretty much like it sounds. You want to show that your conduct during the preference period, or your transactions with the debtor during the preference period, comport with how things are done ordinarily in your industry. There are some typical issues that come up when arguing industry standard. One is, what industry are you going to use? Is it the industry of the defendant, or is it the industry of the debtor? How narrowly do you define the industry? Case law is not that clear about some of these issues. There isn't a lot of case law. There's a ton of case law on ordinary course, and it's still difficult to figure out. But with industry standard, there's even fewer cases, much fewer. So it's harder to predict how a court is going to rule on an industry standard defense. The other problem with industry standard is, to prove it, you typically need expert testimony. Experts are very expensive. That's the first problem. It's $5,000 probably just for an affidavit or an expert report, probably between 5 and 10, depending on the complexity of the case. And then if an expert is involved further in the case, there's even more and more cost, which is one of the reasons I typically form groups of defendants. So if I have to retain an expert, I can try to share that cost. The other problem with an expert is that the plaintiff is going to get their expert, and then basically it turns into a battle of the experts, and it ends up being very hard to predict the outcome. It becomes sort of a coin flip. The third and last defense I'm going to talk about is called the new value defense. This is a very powerful defense. It's usually you either have it or you don't have it. I'm going to go into explaining how to present it a little bit. It's based on 547. This is the definition of new value, 547A3. The way it works basically is you get a check in the preference period. That's an alleged preferential transfer. Let's say I call that the first check. And then you deliver a product or a service after you receive that check. Not an invoice. We're not invoicing. I'm not talking about an invoice, but I'm actually talking about actually delivering the date and time you deliver a product and get someone to sign for it, or when you deliver your service and you have time records to prove it. And if you do that and you're not paid for those services, or you're not paid for that product, then you may be able to set off the value of your product or service against the previous transfers. In other words, that's why it's called the subsequent new value defense. The new value is subsequent to the alleged preferential transfer. So it can be a little bit frustrating sometimes, because let's say the first check is $10,000 check. You delivered a product worth 30,000, and then the second check is again 10,000. So the problem is it's frustrating because you can't set off the $30,000 in value that you delivered. You can only set off the 30,000 against the first check, which just wipes out $10,000. But you can't set it off against the second check. Why? Because it's not, you didn't deliver the product or service subsequent to the second check. So it doesn't accumulate. You can only use it against previous transfers. It gets a little complicated because you have checks, then you have a value given, then you have more checks, and so forth. So typically we do a spreadsheet. This is what a spreadsheet looks like, and basically we have a running balance of what the net preference is on the right side of the spreadsheet. Yeah, the new value has got to be unpaid for. There is litigation on this, but I would say most of the time, most courts have found that the debtor could not have paid for that product or service for you to be able to set it off against the previous transfer. There is some litigation about this, whether paid new value might be permissible, but that's beyond the scope of this slideshow. Okay, I'm just going to go very quickly into the stages of a preference case. Complaint is filed, answer. This shouldn't be surprising for the lawyers out there. It's basic routine. Complaint is filed, and you have to file an answer to the complaint. There's a call between the two lawyers, defense lawyer and plaintiff lawyer, regarding discovery. Usually there's a status conference, not really a pretrial, since trial usually hasn't even been set, or it's a long way off. There's a scheduling order that sets deadlines, usually discovery deadlines and motion deadlines. Discovery exchanges happen at some point, depositions, motions for summary judgment, and trial. Trial is extremely rare in preference cases, I think largely because there aren't that many fact disputes. Usually it's a dispute about the application of law to the facts, and that can be resolved usually by a motion for summary judgment. Scheduling order, like I said before, is just a list of deadlines that help move the case along. Instead of going into the discovery process, we'll discuss the settlement process. We use what we call a position statement. It's a legal brief that summarizes all the defenses that we have, and we have exhibits to that. And we find it extremely effective to present the plaintiff with our case early in the case and see if the plaintiff can poke holes in it, and see if the plaintiff is willing to settle very early in the case, especially in preference cases. Once the plaintiff receives a position statement, typically what we find is we'll get an offer, and the only issue is the offer reasonable to my client or unreasonable. If it's unreasonable, then we continue to litigate the case. Mediation is ordered in a lot of preference cases. In Delaware, it's mandatory, but a lot of courts like mediation, and a lot of cases are resolved during mediation. Typically you have to have a mediation statement. So our position statement usually is just renamed, and we use it as a mediation statement as well. Summary judgment motion is if nothing else works and we really have to file a motion to get the case dismissed, or just to get the plaintiff's attention, then we'll do that. Summary judgment motions are usually controlled by a deadline, and usually they're filed after discovery and prior to the summary judgment deadline. Obviously, the typical scheduling order will have mediation first, so that neither party spends a lot of money on a summary judgment motion before trying to settle the case. Outcome of preference cases. There's a lot of case law on preference cases, a lot of case law on ordinary course, and many of the other defenses, so that it's not easy to predict what's going to happen, but it's fairly predictable, and that's another reason these cases don't go to trial, because there's a huge body of predictive case law, and so it's futile to bring a bad case to trial, and a good case is going to be settled on a favorable basis by the plaintiff, and a bad case, the defense is not going to want to bring to trial. It's a waste of time and money. Motions for summary judgment are also pretty rare. What I find is that if I'm just not getting any attention, I'm just not convincing the plaintiff of my position as a represented defendant, then we'll draft one and serve one. And I would say more often than not, we're going to settle the case before the motion is even heard. Yeah, that's another thing about trial, is that a typical preference case, a lot of preference cases are $50,000 less, considering that it costs $30,000 to prepare even a small case to go to trial and through trial. It just doesn't make sense to have trials. Thanks for listening. What I tried to do is sort of give you sort of an insider view of what goes on in a preference case. I hope that's been helpful.